Next, we're going to look at 3 issues that are really concerning brokerage relationships. And in this section, we're going to be looking at, first off, agency versus transaction brokerage. We're going to be sort of defining those 2 things. I know we've talked a lot about that in the past, but it's pretty important to revisit it one more time. Then second, in this section, we're going to be talking about the seller reduction of uniform duties, reducing the uniform duties that you as a licensee are obligated to perform that you find in Section 4 of the listing contracts. We're going to be talking about that, what happens if the seller asks you to reduce some of those. And third, in this section, we're going to be looking at the use of the brokerage duties to seller addendum. This is the addendum that attaches to REO, that's real estate owned or non-Colorado Real Estate Commission approved listing contracts. So these are the 3 things that we're going to be reviewing in this section. So first off, we're going to be talking about agency versus transaction broker. And when we're talking about agency and transaction broker, really it boils down to a fiduciary relationship issue. And when you have a fiduciary relationship, which we're going to define here in just a little bit, problems come in when there's a breach of that fiduciary relationship. So we have to ask the question, and we're going to define it here, as I said in just a little bit, what is a fiduciary duty? And when we define that, then the question is, who has a fiduciary duty? And then we're going to look at fiduciary duties within relationship of agency and transaction broker. But it's important right off the bat here to really say that the purpose, the intent of this section is to reinforce 2 primary ideas. Idea number 1, agency relationships come with fiduciary duties, and not performing those fiduciary duties increases legal liability for the broker and is a violation of Colorado Division of Real Estate rules. And on the other hand, a transaction broker has no fiduciary duties. And for a transaction broker to perform fiduciary duties would increase their legal liability, and that would be a violation of division rules. So let's now look at what a fiduciary duty is. A fiduciary duty is a legal obligation of one party to act in the best interests of another party. The obligated party is typically called a fiduciary, and that is somebody who is entrusted with the care of money or property. The fiduciary has a relationship of trust with another. So you also need to note that a fiduciary duty extends beyond the transaction and into the future. For example, say you're working with the seller, and the seller wants her motivations for selling the property kept confidential. The fiduciary duty, if that seller and you have an agency relationship, that fiduciary duty is obligating you as her agent to respect her wishes after the closing. It extends beyond the closing. So who has fiduciary duties? Does a licensee with an agency relationship have fiduciary duties? The answer is absolutely. But then the next question is, does a transaction broker have fiduciary duties? And the answer there is they do not. There is no agency relationship created that creates a fiduciary duty. So there are 2 issues that we deal with regard to this. First issue, a licensee with an agency relationship who is not performing fiduciary duties is not protecting their client's interests. Or even worse yet, maybe they're protecting their own interests as the broker, and they're placing their own interests before their client's interests. That's a bad situation. Second issue that we see with this, transaction brokers acting as if they have a fiduciary relationship. So if you're a transaction broker, technically you're supposed to be neutral. You're supposed to be a facilitator. Okay? You don't have an agency relationship. You don't have this fiduciary relationship. But when somebody assumes a transaction brokerage relationship and then they give advice to the party that they're working with as if they are an agent and they're pretending like or trying to represent their client's best interests, that's a violation of the neutrality issue that transaction broker needs to be. So both are equally bad issues and land people into court and in hot water. So it's important here that we really sort of define transaction broker and agency and try to sort of set up how this really works. Remember, in Colorado, a broker must either be an agent or a transaction broker. If a broker is an agent, there has to be a written agreement between the broker and their principal, which creates that agency relationship. But a broker can be a transaction broker by either entering into a written agreement, which they can do with the exclusive right to sell listing or the exclusive right to buy. It can be done as a transaction broker or simply just through disclosure only. If a broker is acting as either an agent or as a transaction broker in Colorado, there are 17 duties that they're obligated to perform, which are known as uniform duties. They are the same whether you are a transaction broker or whether you are an agent. And the uniform duties can be found in Section 4 of the listing contracts. You can also find a copy of the uniform duties in Appendix A of our printed material and as an attachment to this online lesson. But those uniform duties have to be done by everybody, transaction broker and agents alike. And if the broker and the party that they're working with determine that there should be an agency relationship between them, then the broker has to agree to an additional 3 duties on top of the uniform duties. But see, the challenge is a lot of people have a hard time explaining the difference between agency and transaction broker, especially to their clients. So we've been trying to come up with ways to help in the explanation. And the best way we can do this, I think, is probably with the sports analogy. For some reason, Colorado seems to be big on football, so I'll use football teams in this example. When you have a game going on, you got 2 football teams, they take the field. Those are the players. We're just going to say that's the buyer and the seller. Those are the 2 teams. And along with the 2 teams, you've got some people running around on the field. They've got the black and white striped outfits on. Those are the referees, just trying to make sure everybody plays the game fair. And on the sidelines, you've got the coaches. This coach for this team, this coach for this team, but those coaches are specific for their teams. When you are dealing with an agency relationship, the best way to describe the agent is they are the coach. They represent only one party in the transaction. They represent only one team on the field. That coach that's on the side of that field, that coach wants to make sure their team wins. Yes? Okay? When you are an agent working with your party, the principal, you are totally in for your team. The coach owes the duties of care, obedience, accountability, loyalty, including the confidentiality we just talked about, and disclosure to their team. But their objective is to help their team win the game. Now, in contrast, when you are an agent, maybe I should say better, in addition to it, remember we said there are 3 other things that an agent must do. If you are the agent, if you are the coach, you must promote the interests of your party with utmost good faith, loyalty, and fidelity. You're there to make sure your team wins the game. You must seek a price and lease terms and rates that are acceptable to your team, to your principal. And you must counsel your team as to any material benefits or risks of a transaction. But you are there to make sure your team is well represented in your fiduciary relationship to them. Now, in contrast, remember we talked about those people running around the field in the black and white striped shirts, those referees? Well, the referees hopefully don't really care which team wins. They're there just to make sure the game is played evenly and fairly. So the best way to describe the referee is as a transaction broker. They can assist one or more parties in the transaction. They can assist one or more of the teams in the transaction. They can work with both if they have to because they should be neutral. So they perform communication, interposition, advisement. Notice advisement is different than advocacy. They aren't advocating for their client. That would make them an agent. But they're advising their client on the details of the transaction that's going on. They can help in negotiation. They can help with contract terms. And they can help in the closing without being an agent or an advocate. But they are neutral. They are the referees on the field. Now, transaction broker was created as a non-agency relationship. And under Colorado law, a broker is presumed to be a transaction broker unless a single agency relationship is created by a written agreement between the broker and the party who is their principal. But agency is only created by a written agreement. And once again, everything that a transaction broker can do is summarized in the uniform duties found in Section 4 of the listing contracts. But a transaction broker, unlike an agent, cannot promote the interests of any party. They're supposed to be neutral, right? They can't seek a price and terms and a lease rate that are acceptable to any party. They have to be neutral. And they are not allowed to counsel any particular party as to the material benefits or the risks of a transaction, because that would make them not neutral. That would be advocacy. That's not advising. So a transaction broker has to truly be a facilitator. They have to be neutral. Now let's move on to the second topic that we want to talk about in brokerage relationships, and that is the reduction of uniform duties. Now again, like we've been talking about, a broker is acting either as an agent or as a transaction broker in Colorado. I know we have a customer relationship, but that is not really a brokerage relationship. That's a non-relationship. So you're either acting as an agent or as a transaction broker in Colorado. And either way, you have 17 uniform duties that must be performed. These are things that you disclose, things that you do, the disclosure, the presentation of offers, not disclosing psychologically stigmatized issues on properties, those things. Those are uniform duties, again, found in Section 4 of your listing contract. If the broker and the client determine that the broker should be an agent, as we've talked about, there might be those 3 additional things that need to be done. But uniform duties, these uniform duties are required not just under Colorado real estate license law, but under the Colorado revised statutes in 1261-804, 1261-805, and 1261-807. So this is statutory law. The broker must perform all of the uniform duties that are listed. Uniform duties cannot be reduced. And any broker that's acting in the capacity as an agent or as a transaction broker that does not perform the uniform duties is in violation of Colorado law and Colorado Real Estate Commission rules. And as these uniform duties are required under Colorado law, a real estate broker is obligated to perform them. All of them. A broker cannot reduce them. An attorney cannot reduce them. A seller, landlord, tenant, or buyer cannot reduce them. They cannot be reduced. And if a seller, buyer, tenant, or landlord crosses off any of the uniform duties in the listing agreement, the broker has 2 options. Option number 1, they can sign the listing, even though their client has lopped off a couple of these things, saying you aren't going to do this. They can sign the listing and still provide all the uniform duties, even though some have been crossed off of the listing. Or 2, they can walk away from the listing by telling the client that they're not going to violate the laws and rules and risk their real estate license. Because, let me just state it again, there is no way to reduce the uniform duties and maintain compliance with division rules and regulations. You perform all the duties or you risk a license law violation. Now, one area sometimes where we see this uniform duties issue being reduced is with regard to builders. When a licensee has a relationship with a builder and the builder says, I don't need you for everything, I just need access into the property. So essentially what we call entry only. And entry only is when a broker is not performing their uniform duties but allowing the client to use the broker's access to the MLS to market homes. So they're putting the information in the MLS, but the broker is not doing anything else. They aren't fielding offers, they aren't presenting offers, they aren't doing disclosures. Guys, that reduction of uniform duties is not allowed. If a broker is representing a builder, the same uniform duties apply. They don't get reduced. Another example of this, some brokers in the representation of builders have not been signing closing statements with regard to the building contracts that they have with the agreements they have with the builders. So they go to closing and there's the settlement sheets, but the brokers aren't signing it. Sometimes the brokers aren't even showing up. You have a obligation under Colorado division rules to show up and to sign settlement sheets and make sure it gets to the parties. It's still required. The law says at the time of closing, the licensee who has established a brokerage relationship with a buyer or seller, or who works on behalf of the buyer or seller, either personally or on behalf of an employing broker, is responsible for the proper closing of the transaction and is required to provide, sign, and be responsible for an accurate, complete, and detailed closing statement. But if you don't go to the closing, how can you sign the statement? And some brokers don't even think they have an obligation to. Please understand, if you're working with the builder and you're closing the deal and you have a listing agreement with the builder, a representation agreement with that builder, you are still obligated to sign the closing statement and make sure that the parties get a copy. And if you're at the closing table and there's not a place for you to sign away. You still need to sign and validate that to comply with division rules. The third thing that we want to look at in this section dealing with brokerage relationships is the use of the brokerage duties disclosure duties to the seller disclosure, and this is for REO, real estate owned properties, or non-commission approved listing contracts. Now, Commission Rule F stipulates this. It states that when the Real Estate Commission promulgates, that means provides, the use of a commission-approved form, that real estate licensees who are licensed in Colorado must use that form. They can't create another form that does essentially the same thing. So if there is a form available for use, you have to use it. But there is one exception, and that exception deals with listing agreements. Real estate licensees can use an attorney-written listing agreement or a listing agreement provided by a seller or a landlord, tenant, or buyer. In this case, those would be called REO, real estate owned, lender-owned properties. That's essentially what that is, lender-owned properties. Or a non-Colorado Real Estate Commission listing agreement. So this is not the approved exclusive right to sell listing contract or exclusive right to buy or exclusive right to lease or exclusive right for a tenant listing contract. That's not what we're talking about. This is something that is created outside of that. If you are going to use a non-approved listing agreement, it is mandatory that brokerage relationships to the seller are disclosed. And that's where you would disclose the duties that you have under these brokerage relationship obligations to the seller. This would need to be utilized with relocation companies, maybe with real estate investment trust listing agreements, possibly the lender properties, the REO properties, institutional owners. These are sort of the big guys with the attorneys that draft their own listing contracts. When they do that, very often they don't have any of these required disclosures that the Colorado Revised Statutes obligate us to disclose. And because of that, we have to make sure that we attach this disclosure of our brokerage relationships, our brokerage obligations, to the listing contract. So if you're going to use a non-Colorado Real Estate Commission listing agreement, you need to review it carefully. Please do that with your attorney. And you need to be looking at items such as indemnity clauses, liability shifting provisions, and other things that possibly could invalidate your E&O policy and run counter to Colorado real estate law. Now, again, the brokerage duties to sellers supplements a non-Colorado Real Estate Commission approved listing agreement, and it sets forth the brokerage relationships that need to be disclosed to your seller. It informs the seller of items that the brokerage is required to disclose by law, that there are uniform duties that the broker is responsible to provide under Colorado law, again, everything found in Section 4, and it's crucial that you as a licensee disclose as much relevant information as possible in order to avoid complaints, lawsuits, and insurance claims. So let's take a quick look here at this form. This is the brokerage duties disclosure to seller. This is for REO properties and non-Colorado Real Estate Commission approved listing agreements. Again, it's sort of exactly like what you've seen before. There's a seller agency box and a transaction brokerage box. You can list there whether you're part of a multiple person firm or a single person firm, and a place for the seller's name, the brokerage firm. All that should look very familiar to you. When you get to Section 3, it defines brokerage relationships, defines in-company transactions. Section 4 details, as we've been talking about, all of the uniform duties, what we disclose, what we don't disclose, what we have to do, what we don't have to do. That's Section 4, all those 17 items we've been talking about. And Section 5, if you've checked the box on the front of the listing disclosure here, as a seller's agent, these items in Section 5 apply to you. These are the additional items you have to do. Then we come over to Section 6. Section 6 deals with the material defects, disclosures, and inspection issues. And it's very much the same as in the listing contract, with the exception that there is no checkbox option in section 6.2.1 for the seller to indicate that they are providing a seller's property disclosure. In this addendum, the seller's property disclosure is optional. Not so much in the listing contract where there's a checkbox. In this case, that checkbox does not exist. So this is the brokerage duties to seller addendum that needs to be attached to a non-Colorado Real Estate Commission approved listing contract.